Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, as the title suggests, we're going to be discussing the K-1 Fiancé visa, specifically the K-1 Fiancé visa interview. I'm going to keep this, this particular video narrowly focused to the U.S. Embassy here in Bangkok, Thailand. Mostly the reason is we're based here in Bangkok, but also there are going to be some protocols I discuss with respect to this specific embassy which may not exist at other embassies, and there may be other protocols which exist at other embassies that may not exist here. So I'm going to try to keep this narrowly focused to Thailand, mostly because I don't want to disseminate any information that could provide that could create confusion. Basically, what we're talking about with respect to the U.S. Fiancé visa interview is essentially the culmination of the entire process. So after dealing with the Department of Homeland Security, briefly the National Visa Center, and finally the preliminary matters at the United States Embassy in order to get an interview date set, the interview will occur. A commonly asked question by clients of mine with respect to this is, do I need to be at the embassy interview? And in some cases it's, can I be at the embassy interview? Some people want to know if they need to be there. Other people want to know if they can go. In either case, the answer is the same. No, you cannot be at the U.S. Embassy interview. I say this with the slight qualification of unless the consular officer asks you specifically to go. There are certain circumstances, not very common, but a consular officer could in theory ask for the American citizen petitioner to come to the interview. I don't think it would be sort of within the spirit of what the entire process is about, and I'll get to that in a moment, but I guess in theory it could happen. However, in most cases where I've seen consular officers want to discuss anything with the American citizen petitioner in the case, they generally do these matters by phone. And you can see circumstances where I've seen circumstances where they've called the American citizen petitioner and requested information about, you know, the ongoing aspects of the relationship, things having to do with, you know, how they communicate, how the individuals, how often they see each other in person, et cetera, et cetera. Those are generally issues that occur sort of in a fraud prevention unit context. There's a specific video on this channel about the fraud prevention unit. I strongly urge folks that are interested in that topic to go ahead and check that out. But that being said, in most sort of routine cases where the issue of the circumstances or the credibility of the underlying relationship isn't really at issue, it's been my experience that for the most part, the adjudicating officer doesn't really need to see or hear from the American citizen. Why is that? Well, the reason is the front part of this overall process deals directly with Department of Homeland Security and their agents and agencies. Department of Homeland Security adjudicates the underlying petition for immigration benefits, and essentially they do the entire adjudication or the bulk of the adjudication with respect to the American citizen, i.e. they're the agency tasked with determining whether or not the petitioner is legally eligible for the benefit, can petition for the benefit, and then go ahead and do some further scrutiny with respect to the credibility of the relationship. So they look into the supporting documentation to ascertain whether or not the agency feels that they are in fact a credible couple and are eligible for the K-1 visa benefits. There's another video on this channel where I discuss what are called RFEs, requests for evidence, and the increased frequency of the issuance of those RFEs. I would urge those who are watching this video who are interested in that specifically, go over to that video because I talk at length about why I think they're issuing more requests for evidence and the sort of factual scrutiny that goes into looking into these visa cases or looking into these relationships in order to ascertain, you know, whether or not the relationship is in fact credible. Stepping away from that specifically, once the case has left Department of Homeland Security and has been approved and briefly goes to the National Visa Center to be routed here to the embassy in Bangkok, the adjudicating officer is not really dealing with the American citizen. They're fundamentally dealing with the Thai national, the fiancé, ascertaining whether or not they have a criminal record or not, etc., or have some sort of legal ground of inadmissibility barring them from entering the United States. During the adjudication and during the interview, three things can happen. The case can be approved, great. Shortly thereafter, the visa will be issued. The visa can be denied. Generally speaking, they need to cite some reason for denial, such as a finding of a sham relationship or a legal ground of inadmissibility. There are many reasons to deny. Those aren't the exhaustive list. And then finally, there's also what's called a 221G refusal, whereby the consular officer can issue a refusal to issue the visa pending further documentation. So as long as one shows up with further documentation related to the case that's been requested by the consular officer, then the case presumably could be approved and move forward. Upon approval, at that point, the case is concluded, and that's basically the end of the K-1 visa process.